Good evening, I'm Andrea Anderson.
I'm Brian Allen. The United States Secretary of Health and Human Services is receiving a letter from 19 attorneys general, including South Dakota AG Marty Jackley.
I-Team reporter Beth Warden looks into that letter and the controversy on both sides of this medical records privacy issue.
The letter addresses the recent Supreme Court ruling on abortion and how it provided for decision-making at the state level. South Dakota's Attorney General signed the letter.
The Dobbs decision came down on abortion, where the United States Supreme Court said this is not a matter of federal law, this is a matter of state law.
Jackley contends that the fallout of the Dobbs decision included the Biden administration limiting the state's abilities to obtain medical records for the use of investigations.
Medical procedures and records are private, and in most instances they should be protected. This concept that you would give absolute blanket immunity and protection from liability to a physician involved in a certain procedure, whether they do so criminally, whether they do so with legal malpractice or licensure issues, is an inappropriate protection.
While Jackley points to getting records for investigations of malpractice or fraud, Jana Farley with the ACLU of South Dakota sees it differently.
They said is counter to this narrative of freedom that we hear so much of in South Dakota.
She's concerned about how the letter could be applied.
Seems to be some chilling motivation behind this letter, keeping the door open for criminalizing people who are seeking abortions or gender-related care beyond state lines.
Jackley maintains this is setting a boundary with the president's administration to allow obtaining medical records in rare but necessary situations.
This is number one, a states' rights issue, and number two, a public safety and health issue. And if Congress isn't going to step in and do anything about what's happening, we will.
In Sioux Falls, Beth Warden, Dakota News Now.